Everybody, we're officially going to get started right at noon, but before we do that, I just want to open with a couple of housekeeping announcements. So thank you for those of you that have joined us here in person. We also have participants that are attending via webinar. So we are recording this session, so we would ask that people that are in the room make sure that your cell phones are silenced. For those of you that are on the webinar, please make sure your microphones are muted and your cameras are turned off. That way we get the clearest recording possible. If you have any questions and you're on the webinar, please enter those in the chat. We will address them at the end of the session. We'll relay those questions to our speaker. And then for those of you that are in the room, please hold your questions until the end and we'll address them at that point. Final note of housekeeping, this session has been approved for CLE credit. The course number is 488664. We'll put that number in the chat. It's also on the sign-in sheet outside the room for those of you in person, and it will be on our website as well. With all of that fun housekeeping out of the way, I would like to introduce our speaker. Chad Montrie is a professor in the history department at the University of Massachusetts Lowell. He is the author of 5 books, including Whiteness in Plain View, A History of Racial Exclusion in Minnesota. And we're delighted to have him here to talk to us today. Please join me in welcoming our speaker.
So are you seeing my image now in the frame fine? Okay, good. Well, good afternoon to everybody here in the room here at the Minnesota State Law Library, I guess the Judicial Center, and then to you who are watching virtually. I want to, of course, especially thank Sarah Larson for reaching out to me and getting in touch about putting an event like this together, and then all the other people sort of doing the support work to set up the technology and make this run smoothly. I will add to my bio, that's the short bio that Sarah gave you, that of course I'm not a lawyer or legally trained, and I'm not even a legal scholar, I'm not a legal historian. So there's a little caveat there in the sense of, what kind of granular detail or sophisticated analysis I might be able to give you, but I can give you what I know, what I've found as a social historian, contribute that to maybe a conversation or conversations that you are having or like to have with one another. And certainly we will have time at the end for you to offer up observations to sort of add to what I've said or challenge some of what I've said, and maybe if you have some questions too. So it's possible that some of you have read the book, Whiteness in Plain View, that came out in April of 2022 from the Minnesota Historical Society Press. If you're interested in purchasing the book, it is available through their website. But if you haven't, I'll just say very simply what it is trying to do is to show how white people kept African Americans out of their neighborhoods, out of their towns, out of their cities, across Minnesota during 2 centuries. So it covers both the 19th as well as the 20th centuries. And they did this with many different methods. There are sort of a variety of things that they relied on to do racial exclusion. We're going to get into that as that'll be one of the main themes that I want to address and sort of investigate with you for the next 45 minutes or so. But the main sort of thing that I came away from with the research, sort of the argument of the book, is that it's really unequivocal. There's a variety of methods that whites are using, but it's unequivocal that racial exclusion was a fundamental part of the state's history. It is a thing that made the present that we're living in. It is not hard to find. That's why the book's title is Whiteness in Plain View. It's around all of us. It was around people in the 2 centuries that I looked at, but people didn't always see it, and people even today don't always recognize it. But I did a lot of work with primary sources, including archival material at the Gale Family Library at the History Center, not too far from here. And it became clear very quickly that this is a thing that's not accidental. White people are doing this very intentionally. The racial exclusion that happens and the whiteness that is the results of that is a thing that they have to do a lot of work to accomplish and to maintain. Once neighborhoods, once towns, once parts of cities are white, are racially exclusive, white people have to do work to make that persistent. It's also not incidental. I didn't have to look that hard to find examples of racial exclusion. In fact, the challenge that I came away from, the archives with was what to do with all of the examples that I had. I mean, it couldn't tell all of the story of Minnesota. It's had to be somewhat selective in coming up with the cases that I would present to readers. And so each of the chapters does that with a particular area or part of Minnesota, trying to demonstrate some of the ways in which racial exclusion is similar across place and across time, but also ways in which it might vary because of class or because of the time period, because of what might be sort of available to whites in terms of the tools or the methods that they could use. So among the many methods that whites use, they're sometimes aided and sometimes hindered by various state and federal court decisions and legislation. And that'll be one of the things, obviously, we want to concentrate our attention on today. And whites are pretty good at adapting to the shifting legal terrain, to the legal license that they have. Sometimes they're getting support from the government. Sometimes they are finding that there's some new conditions placed on the legal tools, that the legalized racial exclusion that they used to be able to practice. And sometimes they see the state blocking them, but they're usually pretty good about adapting to that, using the tools that are at hand, or if they're being blocked or hindered, finding something else that they can do. And I make this point at the beginning partly because of the way that the discussion that we're having now about racial exclusion in this country, both academics as well as people, I think, in terms of outside of academia, has been shaped, I think, fairly significantly by another book, Richard Rothstein's book, Color of Law. And some of you may have read this book. He says at the very beginning of The Color of Law, Richard Rothstein says very explicitly what he's going to do is show how all racial exclusion is de jure. All racial exclusion can be traced back to state action. And he wants to do this, he says, because that'll make a much stronger case for reparations. And it does, right? But I am, I guess, a certain kind of historian that I can't not see the complexity of the past, right? And I think this idea that racial exclusion is all about the state, even if that's like a good foundation for trying to do something about making change and improvements in the present, I can't accept that, because what I found in all of the various examples that I presented in the book, as well as others that aren't there, is that racial exclusion is a lot more complicated. And actually, I'm a little concerned about what it means if we're focusing on the government's role. On the one hand, we could say that the government is enacting and enforcing policy that required whites to honor the color line, that essentially the government is forcing white people to be racist. Or we could say that white people are demanding that their government give them license and tools to establish and defend it. But those are two different things, right? That's putting government in a different place. And I think, much more partial to the latter idea, that white people want to do racial exclusion and they try to rely on the government to help them to do that. And when the government doesn't, then they find other means. And so if we're going to tell the full history, the comprehensive history of racial exclusion, sometimes we have to go looking for what those other methods were, and not narrowing our perspective on simply what local or state or federal policy might be in terms of legislation or court decisions. For Minnesota and the Twin Cities in particular, I think we also need some clarification on racial covenants. There's a lot of good work being done with the Mapping Prejudice Project, a lot of volunteer research going on to uncover the racial restrictive covenants on deeds. I think they've accomplished this for all of the Twin Cities, and they're moving on to different places. And that has been a very important sort of reveal of how extensive racial exclusion was in the Twin Cities, and suggests a lot more about the rest of the state. But there are some things that we need to say about these racial restrictive covenants. I hit snooze there on. Okay. All right. And I'm going to start a slide presentation here. to go through some of that. All right. I'm going to just again, this is something that maybe many of you here in the room or those who are participating in this virtually may already know, but I want to just go through some of the basic outline or chronicle of the U.S. Supreme Court cases that are relevant to understanding racial restrictive covenants, and to have that sort of be the background for what I want to say about how we might, again, have like maybe sort of a little bit more of a critical, take a more critical view of the place that racial restrictive covenants have in terms of the history of racial exclusion. So one of the U.S. Supreme Court cases I think are important understanding this is Buchanan versus Worley in 1917, which of course comes out of Louisville, Kentucky, when the city of Louisville is sort of trying to figure out how to do segregation without violating without passing laws that would be unconstitutional. They come up with this idea of telling blacks and whites that they have to live on streets where there's a majority of their race, right? And that would somehow be fair because it wouldn't discriminate against anyone. It would just say that you have to live here or you have to live there depending on your race, but everybody has to follow this legislation, right? The Supreme Court rules that can't be done because it interferes with the property rights of people who might be wanting to sell their homes, right? And so that does away with the idea that the cities might be able to do segregation in this manner. And what it does is then pushes whites to figure out some other means, some other mechanisms, and among other things, they come up with zoning, and so then eventually has a long history that stretches now into the 21st century. And we can get into that in the questions portion, or if you want to make some comments about it. But the other thing that they do is start using racial restrictive covenants more in a more widespread and in intensive fashion. They're already doing that probably by the first decade of the 20th century, but they don't really start doing that to much great extent until the 1920s, after Buchanan versus Worley. And then in Corrigan versus Buckley, the U.S. Supreme Court decides or rules that these racial restrictive covenants are legal, that people can use them, and that sort of gives credibility, gives U.S. Supreme Court sanction to the covenants, and then you see them being used even more by developers who go in, buy up land, and do especially suburban housing developments, streetcar suburbs at this point. And so you're seeing them in a lot of deeds that are from the 1920s and into the 1930s and even into the 1940s. But then in 1948, there is another U.S. Supreme Court decision, Shelley versus Kramer, the lead case for that coming out of St. Louis County in Missouri, where Ferguson is. So there's an interesting way in which what happened in Ferguson when Michael Brown was killed is actually connected in Kinloch and Ferguson, how that's connected back to the long history of racial exclusion that is part of where the Shelley case comes from. But in Shelley versus Kramer, the U.S. Supreme Court doesn't say that restrictive covenants are illegal or that they're unconstitutional. What it says is that state courts can't enforce them, right? And then after 1948, then no state court can enforce them, so they don't really have any power anymore, right? People aren't going to use them. They can't use them because if the state court can't enforce them, then there's no way that that's going to help them prohibit an African American from buying a house that a person might want to sell to them. There's a moment just after Shelley versus Kramer when whites think they can do sort of a workaround, where they start to say that if a white person in their neighborhood or their community sells a house to an African American, that will lower property values for all of the other white people living in the neighborhood, and therefore that white seller would owe damages to the rest of the white community. But in 1953, this U.S. Supreme Court hears a case to decide about that, and Barrows versus Jackson, and they rule that this can't be done either. So that's really the end of racial restrictive covenants being a tool for doing racial exclusion. However, I follow, although I live in Boston, Massachusetts, I do follow the news here, and people send me things that are, about what's going on. I follow what Mapping Prejudice people are up to in terms of how that project is moving along and evolving. And I very, every now and then I'll see a story in which somebody is not quite getting this history right, and there are implications for the errors that they're making. So for instance, the Minnesota Public Radio ran a story that was in print on their website about racial restrictive covenants in Rochester. The story came out in the summer of 2022. And this is a quote from that article. Racial covenants became illegal in Minnesota in 1962 and illegal nationally in 1968. The reason why they're using the year 1962 is because the state of Minnesota passed a law to stop some housing discrimination, which would go into effect in 62. And I'll get to the history of that law. 1968 is the year that the US Congress passed the Fair Housing Act. So they're referring to 1962 and 68, a state law and a federal law, as being when racial restrictive covenants became illegal. And that's just simply not true. I emailed the journalist who was responsible for this, or at least had the byline on the story, and she told me that they originally had a chronicle of events that's much more like what you see here on the screen, but then someone from Mapping Prejudice got in touch with them and told them that while there was a Supreme Court decision in 1948, that racial covenants remained rampant and there was evidence that they were still enforced. And that's just wrong. That's not the case. She asked me then, well, is there a debate among historians about this? And I said, no, there's no debate. I referred to some of the books and the literature. One of my favorite books that I think is like just about the best comprehensive treatment of racial restrictive covenant history is Unjust Deeds. You could check that out. It's from the University of North Carolina Press. So, I told her, what I knew from Minnesota and also what else other historians have found. And she wrote back to me to say, well, since they had already changed the article once as a result of reaching out to Mapping Prejudice, that they would not change it again at this point. So they just ran an erroneous report on restrictive covenants. Another Minnesota Public Radio story on Ramsey County restrictive covenants had a line that went like this. Mapping Prejudice technical lead Michael Corey said the earliest known covenants in the Twin Cities date to 1910. In the following decades, the practice grew at the behest of real estate agents and developers. Corey said covenants, often mentioned in housing advertisements, continued even after 1948 when the US Supreme Court ruled the clauses unenforceable. And that's also not true. Then there's a story in the Tribune around the same time that included this claim. Though the US Supreme Court ruled in 1948 that covenants were unenforceable, they continued to be applied, a point that I think they're taking from Mapping Prejudice. And that's just not true. There's no state court enforcing covenants. No one is using them to do racial exclusion anymore. Maybe there is some evidence where someone might have tried to do this. I haven't seen anyone present an actual example of this. And even if they did have an example, it wouldn't show that people are continuing to use this as a tool. It might just be that someone's thinking that they might be able to get away with it, and they would have been prevented, right? If they wanted their transaction in terms of a house being sold to be legal. The other thing is that even in the years before 1948, before Shelley versus Kramer, developers don't usually talk about the covenants. They don't usually talk about them when they do advertisements for trying to attract buyers for houses that they have been building. They don't say, and these houses have restrictive covenants on them. There are some cases of that. Usually those are things that are where developers are operating in the South, but especially in the North, they know to be more discreet. There are cases where something happens and an African-American family buys a house from whites that has a covenant on it, and then it goes to court, and then sometimes the African-Americans win because of some error in the documentation, but usually the white person will win. So we do have examples of people challenging this on both sides or engaging in sort of disputes and conflict about it. But I haven't seen any evidence after 1948, or certainly not after 1953, that anyone is actually using these and getting the state court to enforce them. It is true, however, and I think this is important to point out, and it's an important part of, I think, how I understand racial exclusion in the 20th century in Minnesota, that these covenants establish a pattern, right? There's a pattern of segregation that they help create, and that pattern that pattern has a legacy that stays around. And so white people in a community in some place in Minnesota, if that community is already white, even after Shelley versus Kramer, they don't have to start from scratch to make that community white. All they have to do is the work to maintain it. That's a lot of work still, but it's not the same as trying to then, have a whole new subdivision or, suburban development that they have to then sort of exclude African Americans from or prevent African Americans coming to without having already established maybe 10 decades or sort of a history of that area being an all-white place. So I guess what I want to do is sort of take you through a couple of examples of how whites do racial exclusion, one of which we'll talk about racial restrictive covenants as being one of the tools, but what that example also will show, and what another example will show, is how there's a whole array of things that whites are relying on to accomplish racial exclusion. And so I'm going to be showing you some more slides now. I just want to make sure, check in that you're seeing all this fine. Okay. And this is a map of Edina. Some of you are maybe from Edina, or Edina, you're familiar with Edina, and it has a certain sort of reputation now, right? But in the 19th century, the village of Edina is an interracial farming village. It is actually unusual in the state of Minnesota for the kind of interracial community that had been created there. There's at least a dozen Black families in Edina. They're mostly centered around the mill dam up along Minnehaha Creek. They're at the north part of this map, at the top of the map. And those Black families are socializing with whites. They organize a Grange, a farmers organization chapter with those whites. They're involved in running the PTA, the Parent Teacher Association, with the whites. They are doing town government service. They're very much integrated into village life, right? So Edina is an interracial place. It's racially integrated. This is a picture of the 6th grade class from 1920. And you can see there are 2 young African-American girls here. This is the Edina school. There are many other kids that are part of these dozen Black families, some of them in other grades, some of them at other schools. Then at the end, just after World War I, developers start coming in and buying up land from farmers, and they are buying the land so that they can build houses. And probably most importantly, in terms of that area around the mill dam on Minnehaha Creek, where a lot of the Black families live, is the Thorpe brothers. They buy the lands just below the creek and create what's called the Edina Country Club District. And this is an advertisement for that. Again, look, and you'll notice they're not saying anything about restrictive covenants. People probably kind of know that is something, or they would have been able to ask, again, discreetly with the realtor or the developer agents that they're meeting. But they don't say anything specifically explicitly about covenants. The desire of Thorpe brothers to create this outstanding district of real character and beauty has been realized. The irregular topography of the land, the curving streets and winding driveways, the zigzag creek, and the various kinds of trees and shrubs which clothe the property are an endless source of inspiration on the home builder. There are 266 homes. There talk about sort of the value and the address for people contacting them. And all of these homes that they're building have racial restrictive covenants on them, along with other restrictive covenants. So racial restrictive covenants are just one of many covenants that developers establish on deeds. But the idea being that these homes will be more appealing. So for instance, like there's rules about what you can paint your house, what you can do in terms of landscaping, whether or not you can park vehicles, around the house. But also there is, in this case, this is a covenant from 1925 on a home in the Country Club District. And there, sort of at the end, I've sort of pulled it out, is a line that mentions that one of the restrictions is about race. And I just sort of clicked on that. You can see at the bottom there, no lot shall ever be sold, conveyed, leased, or rented to any person other than of the white or Caucasian race, nor shall any lot ever be used or occupied by any person other than one of the white or Caucasian race, except such as may be serving as domestics for the owner or tenant of said lot, while said owner or tenant is residing thereon. And so because of that exception to the racial restriction, through the end of the 20s and into the 1930s, there are actually hundreds of African Americans who are living in these homes because they're servants for the white families. And I found them in census manuscripts because they're considered to be residing in those homes. So they show up in census manuscripts in the homes of these white families. They're doing housework, they're doing yard work. But at the end of the 1930s, and certainly by the early 1940s, those people also have disappeared from the census manuscripts. So they're no longer residing with the white families. They're probably still working for white families, but they're living somewhere else, and they're coming there to work for the day and going back somewhere else, probably Minneapolis. And of course, in 1948, those covenants are no longer enforceable. By that point, the Edina Country Club district is built out, and it is all white, and it stays all white. But after 1948, it's not staying all white because of the covenants, but because other things that whites have available to them, including being able to rely pretty well on realtors, not to show houses or sell houses to prospective African-American buyers. But the other thing is the racist culture that these people managed to create, construct, or craft around them, starting in the 1920s into the 1930s. If you look at the newsletter that the Country Club District published in the 1930s, you find references like this to minstrel shows, blackface minstrel shows. This one is from 1938, it's the front page, and it talks about a blackface minstrel show that was performed at the St. Stephen's Episcopal Church, which is located right around that area where the mill dam was on Minnehaha Creek, right where those black families used to live, right? That has now become a place where they're performing blackface minstrel shows. Their figures with pillows and danced and sang and got across their jokes with just the right punch at the minstrel show at Edina School Auditorium on April 21st and 22nd. They ran the laugh temperature of their large and appreciative audience almost beyond the breaking point. And there are many people in the residents who are residents of Edina Country Club who are doing the show, putting the show together, including their kids, and there are many people in the audience. So in Edina Village in the 19th century, this would never have happened. No one would ever have allowed this to take place because of the way that the black families, those dozen black families, are integrated into community life. No one would ever have tolerated this. But once that neighborhood goes all white, once the Edina Country Club District is built, the farmers are gone, then they can do things like this. And these minstrel shows will last at least into the 1950s, if not into the 1960s. And it creates a place where black people don't feel comfortable, may even feel like they're in danger, right? And so this is another tool that I think is important to recognize, and it exists and continues to persist after racial restrictive covenants are no longer enforceable. It's an important part of the story of racial exclusion in Edina. Just on the other side of the creek is a neighborhood that becomes known as Morningside. And Morningside was at one time a part of Edina, but broke off in the 1920s, separated. It also was once, farmland. And then developers came in and made it into suburban homes. And you can see sort of how the lots are being platted out here. But they don't have restrictive covenants on them. Even in the 1920s, when they're being sold and the homes are being built, this area of what is really kind of still Edina, it's an area that also is an all-white community by the time the homes are built on the lots, but it's not because of covenants, because none of these properties have covenants on them. So that tells you also that even before Shirley versus Kramer, whites can use other methods and do use other methods to maintain or to enable themselves to keep African Americans out. However, in the end of the 1950s, there is a black couple, Mary and Marion Taylor, who decide to come out to Morningside and buy the remaining lot, which is at the very end of Scott Terrace, which is the second street from the right there on the map. And they have to do this because they're getting pushed out of their own home in Minneapolis. 35W is being constructed. It goes right over where their house was. And so they decide they're going to move out to the suburbs. They buy this home. They buy this lot that's empty in 1959, and they start the process of trying to get the permits to build a house there. And white people find out that they're doing this, and a group of whites in Morningside then organize themselves to stop the family from moving in. Other whites, however, organize to stop the people who are trying to stop the Taylors from moving in. So there's not a consensus in the late 1950s among whites that Morningside should continue to be an all-white place. But it becomes sort of notorious. It gets a lot of news attention. And so people from throughout the Twin Cities, as well as even in other parts of the United States, start writing letters to the village council and other people to tell them what they think about this. And this is from a resident of Minneapolis, Al White, January of 1960, writing to the Morningside Village Council. Gentlemen, I have been reading about the Negro couple purchasing a lot in your exclusive, lovely suburb. I wonder if you realize what it would do to the value of your property if they are permitted to build. If you allow one Negro in your select community, there's a chance others will follow. All you have to do, in my opinion, is to use this property for public uses to prevent them from building. There are plenty of homes to buy on the 4th Avenue South where I am, and sure they would be welcome and have better living. It seems it is in the utmost desire of Negroes to try to get into all white neighborhoods. The white man must be on alert, if for nothing else, but for the protection of their children and grandchildren. So we hope you will take the heed before it's too late. And actually, this is what they do. The group that's trying to stop the Taylors from moving in, they go to the village council and they say, because of where the lot is at the end of Scott Terrace, which is a kind of a steep hillside, that should be held for drainage purposes. That if a house is built there, that'll interfere with the drainage, infrastructure of the area. But the village council rules against them, and the Taylors get to build their house. However, that doesn't end the difficulties or challenges that they face. When they go to the bank, Marion Taylor, who's actually a veteran, has a hard time using his veterans benefits to get a mortgage. When they go to the village, again, to get permits for different parts of the process of construction, they get a lot of people asking questions and blocking their permit applications. Eventually, they get to the point where they can build a house. They do, and they bring with them to their new home Greg Taylor, their son, and he is here in the middle of the picture. This is 1960 Morningside Elementary first grade class, and Greg is there. And Greg continues to go to school in Edina as the Taylors settle in. And this is the yearbook for his high school when he was graduating in 1972. This is Edina East High School yearbook. This is 24 years after Shelley versus Kramer. It's a decade after the state of Minnesota passed fair housing legislation. It's 4 years after the US Congress passed a law, the Fair Housing Act. And it's 2 years before another Black family will move into Edina. Greg is the only Black student in his high school still in 1972. That tells you that even though the Taylors move in, the experience that they go through is, even though that they sort of manage to get through the gauntlet, that dissuades Blacks from trying to get into Morningside to follow the Taylors, with the exception of this other family that moves in. The other family moves in, and that not too long after that, the Taylors actually move away, right? So Morningside and Edina, they stay pretty much all white places. I'm also going to show you something about the shifting legal terrain that whites have in terms of this fair housing legislation I've referred to at the state level in 1961. This is a law that comes out of, it's kind of almost a direct reaction to, or it's sort of a reaction to the troubles that people were facing in terms of discrimination in the wake of the urban renewal projects in Rondo and the highway construction project in Rondo that makes 94. But I'll go through the law a little bit here, and then we'll talk about Rondo and how Rondo and what happens there leads up to the passage of this legislation. The Minnesota Fair Housing Law, which is kind of early, relative to what's happening in other states, passed in 1961, goes into effect in 1962, prohibited discrimination in rentals, property sales, and financing based on race. and I think also national origin. It included several exceptions, however. It excluded apartment buildings with owner-occupied units. So if a person lived in the apartment building that they were renting, they could discriminate. Rooms in owner-occupied homes, if they were renting a home, or renting a room in a home where they lived, they could discriminate. And single-family dwellings without government financing, which was nearly 2/3 of the Twin Cities homes at the time. So if a veteran shows up and tries to use their veterans benefits, that they have for service to their country, that's not gonna, they're not gonna be able to, someone can still discriminate against them at the bank for that, although the federal government has actually intervened at this point in terms of policing discrimination along those lines. But it creates sort of a murky area, right, where only conventional financing is covered, at least by the state law. There is a state agency that is in sort of given the task of enforcing the law. 1963, the State Commission Against Discrimination, or SCAD, begins handling housing complaints, but it doesn't really have a lot of power. It has no temporary injunction power. So if somebody makes a complaint and they think there's reason to think that that might be legitimate, they can't stop what's going on. And if they don't stop what's going on immediately, oftentimes it's too late by the time they come back to do any kind of like fix to what discrimination had allowed. They also can make recommendations and say, oh, this was discrimination, but there's nothing binding about their recommendations, right? And almost immediately after SCAD starts doing its work, legislators who are not, wanting to see discrimination, housing discrimination banned, they do what they can to eat away at the budget, or at least stop the state commission from getting any kind of increases in their budget that would allow them to do their job more effectively. So where does this law come from? And we'll also talk about sort of what happens after the law. It actually comes out of Rondo, and we're not too far from that here where we are. There is in the early 20th century, some sort of a growing Black population in Rondo. The various people oftentimes getting moved out of various other parts of Minnesota in outlying counties, either moved to Minneapolis or moved to St. Paul, moved to Duluth. Many of the people moving to St. Paul moved to Rondo, which is just the west side of the state capital property. But in the 1950s, the St. Paul Housing and Redevelopment Authority decides that they're going to do 2 urban renewal projects, and they begin that process. And this has a dramatic effect on the Black population there. The other thing about Rondo, though, is it's not only the largest concentration of African Americans in St. Paul, it's actually also the most racially integrated. There are also many white residents of the Rondo neighborhood and areas around Rondo. And in some cases, this integration is in the same household. There are a lot of interracial families in Rondo. You can see some of this interracial community in the pictures of different institutions, different organizations. This is a group of kids that are part of a club, and they're going off on a field trip. You can see both Black and white kids there. This is a St. Peter Claver class, and you can see the racial integration there. This is a church and a school, the Catholic church and school, that is run by an order of Black nuns. It's also a church that has, at least early on in its history, has one of the 5 Black priests in the country who comes there to run both the church and the school. So people in Rondo, they not only, they're living in a place where there's a thriving Black community, but they're living in a place that's unusually racially integrated, kind of like Edina was in the 19th century. And they know this. And if you read the Black Oral History Project interviews and other records, you can hear them talk about that. They know as they're growing up that they live in an unusual place, and they know what the boundaries are for that tolerance. That if they go past Lexington Parkway, for instance, that they're not going to have the same kind of experience as they do if they stay on the other side of Lexington Parkway. And the St. Paul Housing and Redevelopment Authority knows that this is a racially integrated place, and they keep very good records. This is from 1958, and it shows what they know about how many white families and what they call non-white families, who are mostly Black families living there, as well as individuals who are going to be displaced by the urban renewal projects. And so, and just also keep in mind, these urban renewal projects are happening before 94. So the displacement that's going on in Rondo is happening already by the early 50s. It's not a highway construction that's initiating that displacement. It's urban renewal projects. There are 472 whites in the Western redevelopment project. There are 136 non-white families in the Western redevelopment project, for a total of 608 families who are going to be displaced from basically Rondo. And then there are some individuals, 885 white individuals. I'm sorry, that's total for the whole Eastern and Western. There are 100 white individuals in the Western section and 52 Black or non-white individuals in the Western section. And then there's a thing at the bottom that shows what's going on in terms of where they end up when they get displaced. And this is a map that pretty graphically demonstrates that Black residents from Rondo don't have the same experience in terms of finding new housing as white residents in Rondo. So the black dots that you see on the map, those are white families, and the empty white triangles there, those are Black families. The black dots start scattering to all parts of areas beyond Rondo, and this map also cuts off some of the places that whites went to. Some whites end up going to Minneapolis or going to the suburbs of Minneapolis, whereas the Black families, those white triangles, they're actually getting concentrated into a smaller area, into the area around the Selby-Dale intersection. And St. Paul Housing Redevelopment Authority knows this. They are very quickly aware that something happened, something went wrong. And what went wrong, they don't necessarily see it as a fault of the urban policy or the urban renewal project, but rather what happens is that Black families ran into a racist housing market. So when white families go out looking for housing, other whites who rent an apartment or own a house are willing to rent or to sell to them. Whereas the Black families that are going and looking for an apartment or a house, they can't just move anywhere. They can't move to a certain apartment or another, buy another house, because they're running into white prejudice. And that's culture, right? So there's a combination here of local, state, and federal policy conjoined with white prejudice. This is from 1957, this newspaper article. Housing project hit as failure. Although generally successful, St. Paul's Western redevelopment project was in one respect a complete and total failure, City Housing and Redevelopment Director Warner Shippey told the St. Paul Council of Human Relations. So, I mean, you also have to acknowledge that the officials who are part of this, they don't seem to have wanted this to be what was the result, right? I think they really did have sincere desire to improve the quality of life in the Rondo area for the residents, or if what happened is the people got displaced, that wouldn't lead to an injustice, right? And Warren Shippey in particular, who's actually a social justice Catholic, he very quickly realized that, well, there's racism that's happening here, and that's a problem for us in terms of what sort of urban policy we're following. An overwhelming majority of Negro families relocated by the project were forced to move into non-white districts, Mr. Shippey said. It was awfully tough to find rentals in other areas where non-white families were welcome, he said. This unwillingness to permit Negroes into other sections of the city will create even more problems of housing as the new freeway system is begun. So they also know now that 94 is coming through, and that's just going to add another, sort of kind of event of displacement. And if nothing changes, then that displacement is going to end up have the same consequences of what the urban renewal project displacement had. 5,000 families will be displaced in the next 10 years, he said, and about 500 of these will be Negro. He said passage of a city housing code and the proposed open occupancy ordinance is both desirable and necessary. Without them, he said, schools will be segregated by geography and children will grow up prejudiced. So his epiphany is, this just proves even more. It's one more piece of evidence we have that we know we have to pass fair housing legislation. Now, St. Paul and Minneapolis at the time are considering bills that would lead to fair housing legislation, but in each case, the attorneys for the cities decide that those bills would be unconstitutional because they would violate the rights of property that homeowners have, or that people that own apartment buildings had, that would somehow interfere with rights that are more important than what rights people would have to be able to rent or to buy, right, and not be discriminated against because of race. And so the city ordinances are blocked, and what people decide to do then is to concentrate their attention on passing state legislation. And probably the one single person who's most important in this is Josie Johnson, who's in the middle here in this picture. She has a good relationship with the governor. The governor helps get a bill out of committee where it had been stuck, and the state legislature passes the law in 1961, and then that is going to go be sort of in force in 1962. But as you saw, and I showed you sort of the basic overview of the law, there are some exclusions, there are some exceptions, which of course Josie Johnson wouldn't have favored, but that was what they had to do in terms of compromise for getting the law passed. And then 94 starts, construction for 94 causes more displacement. And because the law has those gaps, and also just because it's not really enforced very effectively because SCAD can't, then you really just continue to see racial segregation. And I'm going to show you a few cases of complaints from the State Commission Against Discrimination files. This is part of a collection over at the Gale Family Library at the History Center, and you can look at more of them if you'd like by tapping into that collection. Actually, maybe I'm going to show you just one or two, and I'll get closer to the end that way, so we don't run over. This is Calvin Taylor versus Mrs. Zver Wagen, case number 5, March 21st, 1963. So this is a year after the law's been in force. And it gives you an example of how white people do discrimination. And I'll just sort of read through some of this. Mr. and Mrs. Taylor had called the owner of the duplex involved at 3649 Park Avenue in response to a newspaper ad, and had been told that the owner would make arrangements with the people presently living there for the Taylors to look at the place. They called her back the day after seeing it and told her that they liked the apartment, but at this time, Mr. Wagen stalled about renting the apartment to them. She indicated she didn't want mixed races in the house, and then indicated that she had a tentative commitment for a white couple to rent the downstairs apartment, with the implication that she would want to check with them before she would rent the upstairs to a Negro. Ms. Wagen was interviewed by the assistant director of SCAD, and he was very negative about the law and also indicated he doesn't approve of any mixing of the races. He also mentioned that his wife had told the Taylors that the upstairs apartment was rented. When the issue was raised about why the apartment was then advertised, he said that people had changed their mind and it was available again. This is also interesting. He is certain that Mr. Wagen would not have told the family that they were refused rental because they were Negroes, since he had coached her not to say that sort of thing over the phone. Consequently, on the basis of these facts, it's recommended that a finding of probable cause of discrimination be found. So they ruled that this is discrimination, but this is not undone, right? This doesn't lead to anything to rectify the problem, and that family isn't held accountable for being racist. Miss Gloria Page versus Mr. Philip Rosenblum, May 1963. Page said that she had answered an ad which appeared in the paper regarding an apartment for rent, and I looked at the apartment the same afternoon. Miss Page called the owner on Sunday. At first, he seemed confused about which apartment she was talking about, so she explained that she meant the apartment building at 1037 Dayton Avenue. The owner, Mr. Rosenblum, asked if she were a Negro, and she said that she was, and he said that he had rented to a lot of Negroes, but she felt that this seemed to bear some relationship to her interest in the Dayton Avenue apartment. Though she had been given no application to fill out, Mr. Rosenblum asked her for character references, and she gave him 2 people in supervisory medical positions at hospitals. Neither of these character references were called, however. Mr. Rosenblum initially told her that he would call in about a week, and after calling him back a couple of times, was told the man presently occupying the apartment had decided to stay. That's a typical thing too, where they just say, oh, actually people decided to stay, or actually my cousin decided to rent it. You know, since it's their family, that somehow trumps them. Mr. Rosenblum defined his rental pattern, which is one of renting only to Negroes in his Eaglehart, Carroll, Western, and Central buildings, but only to whites in Dayton Avenue apartments. And the procedure of asking for credit or character references is applied only in the case where he has had Negro applicants. And other property owners are doing the same thing. They're asking for references for prospective Black renters, or in the case where they're trying to sell homes, only from those who are African American and not whites. See, this one is about a house. So I'll show you this one, and we'll move on to another slide and get closer to ending. Mrs. Alpha Adkins versus Mr. Guy Prescott, November 26, 1963. Upon visiting an open house, the complainants were refused the right to see the house, to obtain any information about it because they are Negroes. The owner of this house admitted refusing to show the complainants his house because they are Negroes. During the investigation, the owner indicated that he would not sell a house to a Negro because they are unreliable and don't pay their bills. And he knows there's a law in 1963, but he doesn't feel any hesitation to say this to a person who's investigating discrimination. It was also discovered that this house, a single family home, is homesteaded and is not covered by any government loans, right? So they also are working these exceptions. You can find other cases that go on into the 1960s, I think maybe even the 70s. So this is persistent. This is not ending, even though SCAD's trying to enforce the law. And then we get to 1968 when Congress passes a federal Fair Housing Act. In April, the bill is introduced by Minnesota's own Senator Walter Mondale, signed into law by President Johnson, which prohibits discrimination in sale, rental, and financing based on race. So, and this helps in places outside of Minnesota, other states that don't have their own fair housing legislation. It also exempts owner-occupied dwellings and excludes sales with conventional financing. So it has some similar exceptions. Then finally, in the summer, the U.S. Supreme Court ruled in Jones versus Alfred H. Mayer that the 1866 Civil Rights Act already forbid racial discrimination in sale or rentals without public funds. So that kind of brings us to a sort of a bookend in terms of what needed to be in place as far as court cases, in terms of legislation that would be, necessary to have fair housing. But of course, racial segregation continues, not only in the South, but also in the North. This is a Metropolitan Council report from March of 1970. The Twin Cities metropolitan area, despite its northern location and progressive reputation, has highly segregated living patterns as a result of housing discrimination. Minorities, particularly Blacks and Indians, are concentrated in a few core city neighborhoods, and as a group live in some of the worst housing in the region. It seems clear that a significant constraint operating to prevent minority persons from being more adequately housed and from having more choice in residential location, in addition to their generally lower incomes, is the pattern of housing discrimination which exists in the area. Political and community resistance to low and moderate income housing is marked in area suburbs. This resistance is evidenced through land use controls of building and zoning controls, opposition to low income housing proposals, which have been submitted to the state legislature, and opposition to provision of subsidized housing in suburban communities. Clearly, the political climate in the region has had a negative impact on adequately meeting low-income housing needs in the region. And these things continue, right? I mean, there's 2023 examples of exactly what they just referred to in this report from 1970, from 50 years ago. And this is why you have this map. This is, I think, 1973, showing you the concentration of African-American residents in the counties around the Twin Cities. And I think I'll try to end there and see if there are any, things we want to sort of go back to for, with any comments you have, or if you want to ask me any questions. So thank you for your attention so far, and see what the audience goes with this.
Well, we do have some questions from the chat.
Sorry, should I do something to the screen so they can see me, or?
Yeah.
Stop share. Okay. I didn't want to shut down the entire presentation for everybody. Okay. All right.
The first question from the chat is, isn't being able to enforce very different from being able to use these covenants? It's confusing talking about what the courts allow versus what people were practicing on their own, saying the covenants weren't used.
Well, the people can't, if someone told a African-American tries to go buy a house in the Edina in 1949, and a white person told them, well, you can't because I have a covenant on my house. That Black person, they actually get referred to in the literature as Black pioneers. They know, the African-Americans know what has happened. They know the Supreme Court case ruled in their favor, and they would be able to tell the white person that's wrong. And if they wanted to, they could challenge that person. That person tried to stop them from buying that house by invoking a race covenant. They could simply take them to court, right? They could debate this, but a white person is going to have to rely on something else for their exclusion to be effective. I don't know if that I understand that sort of what they're saying, but Black people are very aware that they now have a Supreme Court case behind them. And Black people knew before, though, that they could challenge the covenants. So there are many cases that come up in various parts of the United States, where even when there are restrictive covenants, they try an angle where they say, oh, somebody didn't sign the right paper or this or that. They're very good at using the legal system to get themselves access to places where they should be able to live. But I mean, sort of the flip side of whites, being able to adapt to the law, African Americans are also quite able to adapt to the shifting legal terrain. And I don't know if you want to go back to that person, if that really answers their question, because I'm not sure if it did.
We do have another question from the chat regarding the fair housing legislation. The question is, how does support for fair housing break down in the legislature? Which blocks of legislators championed it? Which legislators opposed it?
Mm-hmm.
You know that.
I do know some of that, like not off the top of my head now, but if you go to I think it's the chapter on Edina, I do a little sort of a breakout section where I talk about the process that is happening, and then maybe also in Rondo, there's some attention to what's going on at the local level as well as what's going on at the state level. And referencing some of the documents that opponents of the legislation were creating. There's a study that the legislature does and funds. I think it includes like maybe 2 dozen, maybe 3 dozen legislators who break down on different sides of the question, and they come up with a certain recommendation. There are some really outspoken opponents of the legislation who are anti-communist, and they fold this into their anti-communism, and they talk about how people who favor fair housing legislation are part of the communist agenda, and they say this is, we need to stop this. And then after the legislation, people are organizing neighborhood groups around the city too to call attention to the fact that now they're going to be inundated with Black residents trying to come rent in their neighborhoods or buy houses there, and they actually talk to one another about, now what are we going to do? How are we going to keep them out, right? And I think some of the representatives for those districts probably are sympathetic to that. Realtors too. You can watch in different documents that the real estate boards produce. They are watching what's going on at both the city as well as state and federal level, and they have different statements about what they think about fair housing legislation depending on which way the wind is blowing. And so that's a lot of that literature is in collections at the Gale Family Library and the History Center. You can find references or actual citations to that in the endnotes of the book. I am an academic, a professional historian, and this is like really maybe, this is probably my second book where I was trying to appeal to an audience beyond just, an academic, academic readers, and maybe I'm not working yet at my best in terms of writing for general audience. So you'll see there's still an overwhelming amount of detail there. I had a hard time not producing endnotes and footnotes that went on and on. And so if you're interested in this thing, if you want to get into the weeds with it, a lot of that reference material is there, a lot of it. And if it's not, email me and I can help you poke around in the collections online search to find something that might be useful.
We do have some more questions from the chat. If there's anyone that has any of these points. The next question that came in on the chat was, were there other options available for?
Yeah, there was another proposal just north of where it is now, and there's actually various arguments for it, including someone said, this is going to divide. This is going to divide the city, and it's not going to be good. And even people that aren't even concerned about what it's going to do to a Black community, they don't think it's a good idea just generally for the layout of the city and how the city would be developing. Initially, there are white business owners and others who are involved in the business community in St. Paul that favor the urban renewal projects as well as the highway construction. And then after they see it starting to not actually work in their interest either, because it's just basically destroying the cohesion of the community, then they even turn against it too. So it's not just the African Americans who find that they end up getting, more segregated and that this forces them into, you know, a racist housing market. But there are actually also various constituencies of whites that realize that this didn't work out well for them. What it does do, however, is help white people get from St. Paul or maybe Minneapolis to white suburbs, right? So they benefit from that. And then people who come into Rondo later, after there's a third urban renewal project and some other things that go on there, and the area gets gentrified and becomes whiter, those people benefit too.
We're almost at time, but we do have a few questions that sort of touch on the same theme of, you know, what does the future hold for in terms of housing segregation and what housing advocates can do in the future.
Mm-hmm. Well, one of the things I think people can be working on is zoning and stripping suburban residents, you know, stripping from them that this claim that they have on blocking multifamily housing. So that they claim that that's not about race, but if you look at it in terms of practice, it usually reproduces patterns of racial discrimination. Of course, blocking multifamily housing can have an effect on people who are not people of color, and so it would help people who are in low income or below poverty line also. But that is that's sort of like a front line where people could be working. Then there's other things like, you know, rail extension. I think they're talking about doing a Purple Line rail extension here to White Bear Lake. And people in White Bear Lake aren't saying we don't want that because that will lead to racial integration or more racial integration. They're saying like, you know, this will ruin the small town feel of White Bear Lake and so on. And we know, and just reveal what that is. Like, put that in context and think about how whites, as I said, sort of relying on various methods and what's the history behind resistance to that kind of, you know, transportation policy or an urban policy, and how might it be entangled with racism or history of racism, right? Otherwise, I'm an historian, and so like really what I can do is show you the past, and it's kind of up to people to take this, especially people that know a lot more about, you know, as I said, law or the, you know, the court decisions and policy, who are working, you know, in CDCs or nonprofits or working for state government or city government. It's kind of up to you to sort of figure out what to do with this, because I think I quickly reach my limit in terms of what I can offer, other than just bumbling and rambling. But
we take several more questions, but we don't have time.
Oh, okay. Well, I'm easy to find on email. If you go to the history department webpage for my university, there's an email address there. I'd be happy to entertain any, you know, observations you have or any questions you have, you know, by email. And I'm also I will be back, and so there'll probably be other times where I'll be talking, because I'm working now on another project about racism in Minnesota, which is sort of going in another tangent, and I will probably be back in the next few months, certainly by next summer, and so maybe there'll be other opportunities for me to engage some of those people. Thank you again for putting this together, and for those of you who are in the room and those of you who joined online, it's a pleasure to be here. Thank you.